All right, well, I see a few folks are still being admitted, but I'm going to go ahead and get us started. Good afternoon, everyone. Thank you so much for joining us. We are thrilled to be presenting this webinar, Media Law Litigation in a Post-Newspaper Future. This panel is sponsored by the ABA section of Civil Rights and Social Justice. It's one of many in a series of our rapid response webinars. We're actively planning additional programming on a variety of issues. So please visit americanbar.org/CRSJ, that's Civil Rights, Social Justice, for updates on these programs. I'm Frank LoMonte. I'm the co-chair of the First Amendment Committee under the section of Civil Rights and Social Justice, and I'm very pleased to be your moderator for this event. My day job is as legal counsel for CNN in Atlanta. I am not speaking on behalf of that employer or any of my other affiliations. I'm a faculty affiliate both at the law schools at the University of Georgia and at the University of Florida, where until recently I was the head of the Brechner Center for Freedom of Information, a think tank about openness in government, which is one of the things we'll be talking about today. During today's program, we encourage you to please ask questions of the panelists using the Q&A feature, if you can, please, not the chat function. If you don't see the controls, please ensure that your screen is not idle. I'll be monitoring that Q&A feature. We'll do our best to address your questions, time permitting. And we will be sharing a recording of this program with everyone who's registered, so you can share it widely with your networks. So I want to introduce our three presenters today, and then just do a little bit to set up the subject matter that we're going to talk about. So with us first, Professor Ronelle Anderson-Jones is at the University of Utah, where she is a endowed chair and professor of law at the S.J. Quinney College of Law. She's also an affiliated fellow with the Yale Law School Information Society Project. She has a background as a local newspaper journalist, and so she comes well prepared to talk about this bundle of issues. She's a widely published researcher and scholar on issues of the First Amendment and the rights of journalists, including in Northwestern's Law Review, Michigan's, UCLA's, Minnesota's, and many others. She's a former law clerk on the Ninth Circuit Court of Appeals, as well as for Justice O'Connor on the U.S. Supreme Court. And she also practiced law with Jones Day prior to becoming a professor. Katie Fallow is senior counsel at the Knight First Amendment Institute, which is a nonprofit that's headquartered up at Columbia University, where her work focuses on threats to free speech and a free press in the digital age, including in social media. She spearheads the Institute's litigation concerning the government's use of social media. Undoubtedly, you've read about the work that the Knight Institute has done on people being blocked by Donald Trump's Twitter account and other government-operated social media accounts. Before joining the Institute, she was a litigation partner at Jenner & Block in Washington, D.C., worked on landmark First Amendment cases, including the Entertainment Merchants v. Brown U.S. Supreme Court case. She is a former law clerk with both the District Court of Massachusetts and with one of my favorites, Judge Barnett, on the 11th Circuit Court of Appeals. And then Professor Lyrissa Lidsky is with us. She is at the University of Florida School of Law now, where she's the Ehrlich Chair in U.S. Constitutional Law. Prior to that, she was Dean of the University of Missouri School of Law. She is a widely published scholar on a variety of media law and First Amendment issues, and is the co-reporter of the Restatement of Defamation and Privacy, in addition to being the author of a number of widely used text and reference books in the area of media and First Amendment law. She too was a former law clerk on the Ninth Circuit U.S. Court of Appeals and was a Fulbright scholar at Oxford. We are just so thrilled and delighted to have such a well-credentialed panel here to join us. I'm going to start us off with a little bit of sobering information that talks about the subject that we're going to talk about, media law litigation in a post-newspaper future. And why are we talking about a post-newspaper future? Because the reality is that fewer and fewer American communities today are served by a well-staffed and well-funded local newspaper. Northwestern University's News Deserts Project publishes a map which updates the harsh reality that as of today, over 200 of the United States' 3,100 counties do not have any local newspaper at all. And then out of the 7,200 surviving newspapers that we still have, over 1,000 of those are what Northwestern categorizes as ghost newspapers. That is, newspapers that have little to no of their own staff, so that they're relying almost entirely on generated news from wire services and subscription services, and almost none of which actually pertains to issues of pertinence to the local community that they're supposed to be covering. You may have read about just last month, a man named Abdullah Garfel Khalifa lost his job as the only reporter left at the St. Cloud Times in St. Cloud, Minnesota, meaning that a community of 70,000 people is served by a ghost newspaper with no more reporters at it. Newspapers have been closing at a rate of 2 per week since over the last 20 years. We've lost 2,500 newspapers that have simply closed or merged out of existence. A lot of this is due to the increasing ownership of newspapers by hedge funds, which now control some of the most storied newspaper chains in America. The Tribune and the McClatchy chain among them are now owned or controlled by hedge funds, which have hollowed out many of these newsrooms for profit. Between 2002 and 2020, the U.S. Census Bureau says that newspaper publishers' revenue dropped by 52%, and the total weekday circulation of newspapers went from 55.8 million to 24.2 million. One hopeful sign, and you can't be a First Amendment lawyer without being an optimist, so we should end on a hopeful note. There is an increasing reliance on nonprofit organizations to deliver community news. The Institute for Nonprofit News, INN, has over 400 members now, 135 of which have started operating just since 2017. They report a combined annual revenue of an estimated $400 million. And so the center of gravity of news publishing is rapidly evolving away from these traditional newspaper chains and toward startup nonprofits, often very thinly staffed and thinly capitalized, with their own set of issues. And we'll talk about all of those. I want to invite Professor Jones to start us off. One of the reasons that we convened this was, frankly, Professor, you wrote an article that I've referred to many times over the years at the Washington and Lee Law Review called Litigation, Legislation, and Democracy in a Post-Newspaper America. And even though this was published back in 2011, it feels like it could be ripped from the headlines today. So can you talk a little bit about your work in that area and about what the role has been historically of news organizations, not just the New York Times, which we know about, but smaller community news organizations and press associations in fighting these battles for access to information and for First Amendment rights, and how that have you seen that change?
Yeah, thanks, Frank. It's a real treat to be here with Lyrissa and Katie, who are two of the smartest and most important voices on these issues in the country, and whose work I absolutely respect and admire. It's been actually really amazing and awful for me to revisit this research of mine in anticipation of this webinar, in part because I've actually never been so sorry to have been even a little bit academically prophetic. And now, like by the time I chimed in with my historical look at this a decade ago, scholars and commentators had already been quite closely monitoring the decline of newspapers for several years, but almost all of our attention had been sort of focused on the ways that the demise of traditional mainstream newspapers might rob us of news, sort of negatively impact the flow of information in a democracy that comes from newspapers that aren't around to do the obviously democracy enhancing work of news gathering and dissemination of information in the public sphere. But I wanted the project to flag, and am now even more concerned than ever about a less obvious, but I think arguably more important consequence of the death of newspapers, which is the ramifications for the development and enforcement of the law. For basically the past century, newspapers and traditional media companies have played a critical role as legal instigators and legal enforcers. And in this role, these entities really claim credit for the establishment and the implementation of some of the country's just most important statutory and constitutional mandates. And it was at the hands of little guys, little local and mid-sized newspapers that this happened. Their death, right, threatens the preservation and enforcement and further development of those mandates. And I think that this threat is sort of nothing less than of constitutional proportions. In fact, over the last several years, as these changes in the media landscape have happened, a lot of new players in the changing media ecology have shown some promise for kind of fulfilling the news gathering and investigative and information disseminating roles of newspapers that have been so important. But there's no one solid apparent successor to this role of legal instigator and enforcer, at least that is sort of as complete and as vibrant and as well-resourced as newspapers collectively were. And that continues to be a dynamic that I think we're going to have to come to terms with and buffer against. So let me just spend a couple of minutes outlining what my research revealed about kind of what we gained legally at the hands of legacy news organizations and what we're, might need to think about what we're losing with the loss of them. They were pursuing constitutional and statutory litigation. They were lobbying for important pieces of open government legislation, and they were pushing for openness in government with these kind of large-scale coordinated efforts. And shockingly, my investigation showed that the major players in all of these areas were newspapers that are now defunct or in serious financial straits. So using these real-world case studies of legal instigation and enforcement by the traditional press, I really did conclude that many of the last generation's most important advances to democracy would be unlikely to be replicated today because the individual newspaper or newspaper-based organizations that spearheaded those efforts just wouldn't be, they aren't around anymore, or certainly if they are around, aren't in a position to litigate the cases or have the financial means to support the legislative efforts on Capitol Hill. And I think more to the point, these real-world examples demonstrate that these efforts are ongoing battles. They're not ones that can be fought once and permanently won. And there's a serious risk of retrenchment now that newspapers no longer exist or are no longer able to fight the fight. There have emerged, and I'm really excited to talk some more with the panel, some at least really exciting entities that are aiming to fill these instigation and enforcement gaps, including pro bono efforts and university-based programs and clinics, proposed subsidies of watchdog lawsuits, the retooling even of open government legislation, and the creation, really importantly, of organizations like Katie's, right, that are engaging in nonprofit lobbying and litigation on behalf of transparency for the American public. But there are serious difficulties in creating at scale the litigation and legislation and funding and incentives that motivated newspapers in their heyday to fulfill the legal instigation and enforcement roles within the media framework. Let me give you a couple of really concrete examples to describe the contours of the historical record here. First, a sizable amount of vital First Amendment doctrine in this country came about at the hands of newspapers that went to the mat for fundamental democratic principles that had public benefits wildly beyond the sort of individual litigants' successes. They weren't litigating for special press rights. They were litigating for the public's First Amendment rights. These instigators, many of whom are now gone or in significant financial crisis, were really singularly responsible for the US Supreme Court recognizing widespread categories of rights that are vital to the nation's participatory democracy. Prior restraint doctrine, doctrines curbing the ability of government to stifle the content of speech, almost all of our doctrine about government access, right, access to criminal proceedings and to important government documents, all litigated by news organizations, but producing holdings that had broad doctrinal protection for all of us. Some of this we know happened famously at the hands of big national newspapers that continue to do quite well, the Washington Post, the New York Times, your Pentagon Papers and your New York Times versus Sullivan and whatnot. But a huge, disproportionately huge percentage of these were brought by newspapers that were tiny conglomerations of newspapers or mid-sized regional news organizations that don't exist anymore, that were in that category that Frank was talking about at the beginning. Among the notable examples is Richmond Newspapers versus Virginia, a landmark 1980 case holding that under the First Amendment, citizens, not just the press, are guaranteed access to the courtrooms in criminal trials absent extraordinary circumstances. The two mid-sized papers that did this, the Richmond newspapers, one of them is gone and one of them is essentially gone. They definitely don't have litigation budgets to be doing that anymore. Press Enterprise, a regional newspaper that served Riverside and San Bernardino County, California, in the 1980s, famously fought not one, but two major public access cases that ultimately were decided by the Supreme Court, again, at great expense in terms of both time and financial resources. And the holdings that emerged from both of those sets of cases weren't media specific. They were bold statements on the needs of a people in an open society, and constitutional rights that we can all invoke, brought to us by mid-sized newspapers that once existed, but no longer do. Now, there are some really remarkable scholars like Victor Pickard who are doing really interesting work on the ways that our reliance on a capitalist commercial media structure has left us diminished as a democracy. But this space right here is one where there's just a quantifiable decline that is linked to the loss of these kind of corporate coffers and the lack of resources to consistently fight the long-term instigation and enforcement battles in the past that sort of served the newspaper's overarching business model, but also unquestionably resulted in a greater public good. And more than this, the stability and kind of unified self-identity that newspapers had during this time period really incentivized them to work together as this cohesive whole to pursue these major changes in the law. And it made them really uniquely well situated to take a long lens, right, to sort of really look forward. And if we're thinking concretely about what we're losing here, that sense of duty to litigate and legislate, push for those things was sort of permanent and forward-looking. So newspapers engaged in significant litigation and legislative efforts that were exceptionally unlikely to have any immediate or meaningful impact on their own immediate bottom lines, right? It's inconceivable, for example, that Richmond newspapers or the Press Enterprise would experience enough of a boost in daily newspaper sales that it would win back the cost of all of that court access litigation that it engaged in. And by the time those cases were resolved by the United States Supreme Court, the moment for running the breaking news story had long since passed. Instead, these newspapers just felt compelled to fight the legal battle because they, like other newspapers in America, sort of saw themselves institutionally as the guardians of these principles. And we've lost that. This same pattern is also seen in the legislation space. So my research revealed, I really expected there to be some examples that didn't sit in this space, but they all did. In literally every state in the nation, the major force behind the adoption of Open Meetings and Open Records Acts and the entities that overwhelmingly invoked them on behalf of the public good after their adoption were newspapers, mostly mid-size and conglomerations of newspapers. And the democracy-enhancing role of newspapers also shows up in a very clear pattern in major movements for important federal legislation guaranteeing openness and accountability. The single most notable example being FOIA, the Federal Freedom of Information Act. The nation's journalistic community brought FOIA right to the congressional doorstep. And they were the principal proponents of it that saw it across the finish line. Margaret Quokka, who is an amazing FOIA scholar, has been doing some really interesting historical work in that space in the last couple of years. But newspapers have also sort of been key, the sort of key users of FOIA for public serving purposes. And her research really plays this out. It was well-funded newspapers that engaged in the most vibrant kind of FOIA activism, using those legislative provisions to access government information that fueled, headlines bringing major national and local issues to light. And they were the ones who had the resources to fight in court when obstructionism kept FOIA from meeting its public serving mandate. And the data pretty clearly tell us that the frequency of open government violations now has increased. When there's no watchdog, people know that they're not being watched, and they engage in behavior that is less salutary. And media resources devoted to seeking legal compliance with open government laws has decreased substantially. So the sort of sum total here is that news deserts, right? They're not just robbing us of news, although they definitely are doing that. But they're also robbing us of litigation and legislation and democracy preservation efforts that we once counted on, even in small and mid-sized markets, that we're now not getting. I'm super excited to think about next steps, sort of what's working and what isn't working in the new litigation and lobbying environment. But at core, I really hope that we'll be sort of squarely asking this, sort of like, whose job is this now? And how do we make sure that they are well-resourced and public serving?
Thank you, Professor. I'll give a +1 shout out to Margaret Quokka's book, Saving the Freedom of Information Act, which came out about 2 years ago and is terrific, highly recommended. So I want to turn to Professor Lidsky. If Professor Anderson-Jones's 2011 article was one bookend for our conversation, yours is the other bookend. You and Professor Christina Koeniggieser, who is actually at Utah, along with Professor Anderson-Jones, have this article coming out in the Virginia Law Review called First Amendment Disequilibrium. And Koeniggieser and disequilibrium are very hard to say. I want you to talk a little bit about that article and about what you've been thinking about in the realm of sort of knowing the field that we're now playing on, right? The diminished capacity of the news media to fight these battles for freedom of the press, for the First Amendment, for access to meetings and documents. What does that mean, and how might the law evolve to sort of recognize this new reality?
So I think the story we tell, it builds upon the work of Professor Anderson-Jones, and is another crucial piece of that story, because we look back to the what I call the golden age press cases, the ones that Ronell was talking about, that the media fought to establish these principles. And in those, we find critical assumptions about the relationship between the government and the media that underpin the philosophy of the First Amendment decisions. And we find that those assumptions are no longer true, that in ways that undermines critical First Amendment doctrine. So let me explain what I mean by that. Brandsburg versus Hayes is a really famous case from 1972 involving 4 reporters seeking to resist subpoenas to testify before federal grand juries on the grounds that it was going to interfere with their right to gather news by interfering with confidential source relationships. And they litigated these cases all the way up to the Supreme Court on the behalf of the idea that the First Amendment might shield reporters from being forced to out their confidential sources. But the Supreme Court, in a closely divided opinion, said no. It said there's no First Amendment right to shield your confidential sources, that the press doesn't get special protections that the public doesn't receive. And this is a really critical line in First Amendment cases. The press equals the public. So the court has gone out of its way to say there's no independent content for the press clause that's not afforded to the public under the speech clause. So they really are worried about having to define who would get those special protections. And sometimes that equation of press equals public works to the detriment of the press, as it did in Brandsburg, where they say nobody gets a First Amendment privilege to avoid being subpoenaed to testify before grand juries. And occasionally it works in favor of both the press and the public, as in the case of access to trials. Both the press and the public have a right to access criminal trials because that is democracy enhancing. It's part of the First Amendment rights that we all enjoy. But the press, of course, litigated those cases, but the benefits accrued to all of us, as Ronell pointed out. But nonetheless, in saying the press don't need special First Amendment rights, the court was assuming a lot of things about the press and a lot of things about the government. First off, they assumed that the press is powerful and they can litigate to protect their rights. They'll take you to court. If you're abusing subpoenas, when you subpoena the press, they will haul you into court. And so it would make prosecutors pull up short before trying to use the press as an investigative arm of the government. So one assumption is that they're powerful. The second assumption is if the prosecutor does abuse privileges, the press will write op-eds and the public will rally behind the press and call out the prosecutor. And so that assumes a level of public trust and public investment in not having the press be abused by the executive branch. I think another implicit assumption is that the executive branch has to play nice because they're dependent on the press to get their message out. They can't go directly to the people. They have a symbiotic relationship with the press in order to function effectively. And so it's a constraining force on the executive branch. At the same time, you've got a powerful and resourceful press that has an adversarial relationship with the government, and it will work itself out without any need for special First Amendment protections to help the press gather news or gather information. They made the same kind of analysis in cases saying the press doesn't get any special access to prisons controlled by the federal government. There's no First Amendment right to that. Neither the press nor the public has that right. But they'll still be able, through their powerful, wily means, to report on conditions within prisons, extract information, get informers, get leaks, and be able to give democracy the information about its government that it needs because they are so powerful, wealthy, resourceful, and have public trust. All of those assumptions are now in question. I think Ronell's work reveals that. There's been a lot of the statistics you quoted at the beginning of the hour about news deserts, ghost newspapers, all of them reveal that those assumptions are being undermined. And at the same time, the Roberts Court is not really that interested in taking press cases. They really don't, there was a period of time where the Supreme Court almost every year would take a major press case, partly because the press were bringing them. And now, even if the press do bring them, the Roberts Court hasn't been taking them over the last 20, 25 years or so. And so we have these hollowed out precedents like Brandsburg sitting on the books with their foundations undermined in very significant ways. And yet we haven't revisited them to see if maybe we need to re-examine and provide more First Amendment rights for the critical gathering of information in our democracy. Now, at the same time, there's another piece of the story. Ronell mentioned that statutory protections have been really important for the press and its news gathering role. In fact, in Brandsburg, the court said, well, you don't need a constitutional right. You can, most states have shield statutes. You can just go lobby for a shield statute. Being able to lobby for legislation, again, assumes that you have resources to hire the people to do the lobbying. It assumes that you can get the public behind you, that the legislature will be amenable to your concerns. They will think that your concerns are valuable. In an era where the press is constantly villainized as a political target by certain public officials, it really makes it much harder to think that they're going to be able to lobby for any special protections within statutes. And another piece of the puzzle is at the very same time the press is being hollowed out and weakened in significant ways, the executive branch has grown stronger and stronger, particularly since 9/11. And so executive overclassification, executive secrecy, all of that is expanding in ways that are going largely unchecked. Our legislature is not checking the executive branch in the ways that we might like. And so we're missing out on critical watchdog protections in constraining government officials from acting unconstitutionally or acting against the public interest. So my co-author and I, Christina Koningieser and I, have proposed a series of possible modifications to existing law that might help. One I would point to that is vitally needed is we should reduce executive overclassification. We've seen it again and again that that's causing problems. And then you have these Espionage Act prosecutions and the government going after leakers in much more effective ways than they used to. The Supreme Court used to assume that leaks were a fact of life. Now the executive branch has been motivated to go after leakers in absolutely unprecedented ways, including making people do what do you call it? Lie detector tests, routinely. Going after, instead of subpoenaing journalists to testify, which at least has some legal protections, secretly getting journalist phone records, secretly getting journalist email records in order to uncover leakers and leaked information, and then threatening the press routinely with Espionage Act prosecutions. So one legal protection might be clarifying the Espionage Act and narrowing it so that it's clear it's not to be used against journalists. More shield laws obviously would be beneficial. What's known as anti-SLAPP laws that protects journalists and others from meritless defamation cases, a federal anti-SLAPP protection or strong anti-SLAPP protections across all states would be very valuable. Codifying Department of Justice guidelines about when to subpoena newspapers. It really depends on the will of the DOJ whether those guidelines are going to be adhered to or not. And so the legislature potentially looking into codifying those to protect reporters against subpoenas issued by the DOJ without significant reason to do so. Limiting records charges. So our FOIA laws are not working very well. Our government sunshine laws at the state level often don't work very well. And one of the reasons is that we don't give enough fee waivers to people that are performing a press function, but that may not be members of the institutional press. So making it cheaper and easier to use our information laws to extract access to information. The other thing is, it really matters in our access laws whether there's a message from the top that openness is the default or secrecy is the default. Government officials, when they're told that there's not going to be any real penalty to secrecy, will default in favor of withholding information rather than providing the transparency that government and the sunshine laws are meant to provide. I would like to see a robust legislature exercise more oversight over the executive branch and deter some of these ways of going behind the scenes and seeking to strong arm the press. I've been very concerned about some of the revelations in the Twitter files about what the government is doing to perpetuate propaganda and ways to get around the press, to get its message out without any check or balance on that message. So I would like to see a lot more oversight of that. To me, the Twitter files, it's as if the Pentagon Papers came out and no one cared, because it really has revealed a degree of government intent to manipulate public discourse in a way that is very concerning. And then finally, I think we're going to need to stop looking to the traditional press to the extent that we have. I think the problem in our model is that we're too dependent on now an outdated economic model for the press. And so these experiments that we're seeing with litigation financed by law school clinics, nonprofit organizations like the Knight Foundation's litigation has been tremendously powerful. Nonprofit organizations like ProPublica, all kinds of creative funding models designed to have someone performing that critical press function, which is not just publication. It's not about opinion. It's about really extracting information from the government in the first instance, and then having the expertise to summarize that information so that citizens can understand what their government is up to, and perhaps put some constraints on what their government is up to.
Well, I want to start to Katie Fallow, who's actually on the front lines practicing in this area. Katie, we've talked in depressing detail about the forest fire that has burned down traditional American newspapers. But when you have a forest fire, you also have green shoots that emerge from the floor of the forest out of the embers. And one of those is nonprofit news, and another is legal clinics of various kinds that are donor funded outside of the normal corporate funding model. Maybe you can talk a little bit about your work and what you see on the scene there, and also just about sort of how the mix of plaintiffs is changing and evolving. I know that your client load includes not just news organizations, but people like immigration judges who are being gagged from speaking to the media, or authors who are being gagged from writing books about their time working for intelligence agencies. And so there's a lot of non-traditional plaintiffs who are kind of carrying the First Amendment load right now in our courts. So you can maybe talk a little bit about that.
Yeah, sure. Thanks, Frank. And it's great to be here with you. We first met when you were at the Student Press Law Center, which is such a great organization, and also great to be here with Lyrissa and Raynell, who's our leading, are two of the leading voices in academia about the First Amendment, and whose own work has been really indispensable to the Knight Institute's litigation and research efforts. But so the Knight Institute dovetails pretty nicely in terms of our story. Is the Knight Institute was founded at Columbia University, but as an independent organization, and it was co-founded by Alberto Ibargüen of the Knight Foundation. And the background on the Knight Foundation is it was established by two brothers who were part of the family that ran the Knight newspapers in the 20th century. And so Alberto and Lee Bollinger, who's the president of Columbia University, and who's also himself a First Amendment scholar, had a lot of discussions specifically about this issue of the extraordinary challenges, maybe decimation, the forest fire, as you said, in your nice, sad but nice analogy, of the newspaper industry, and recognizing both that the newspaper industry was no longer going to be able to play its traditional role in advocating and pushing forward these public interest minded First Amendment issues, and that there were a number of free speech challenges that had arisen as a result of the digital age, the advent of the internet and social media and technological advances that really needed advocacy, such as including about increased government secrecy, which Larissa's already alluded to, but also things like the increasing availability of surveillance technologies and the use of government surveillance, and the impact that government surveillance of speech can have not just on your privacy rights, but on your First Amendment rights. So the whole purpose of the founding of our organization was to establish an independent organization that had good funding to both do actual impact litigation and research in the area of First Amendment, particularly focused on, free speech in the digital age, broadly stated. And as we've all sort of acknowledged, we certainly are just one of the newer organizations among a somewhat small, but I think important and impactful group of other speech organizations. The ACLU traditionally, the Electronic Freedom Foundation, SPLC, the Reporters Committee for the Freedom of Press, CPJ, Committee to Protect Journalism, et cetera. And those are all great organizations. And I don't know everybody's finances, of course, but I do think that there has been an interest among philanthropic organizations to in the past maybe 10 years to increase their funding of these kinds of organizations to fill that gap that we've all been talking about. And then there has been, as everybody said, maybe mini explosion of First Amendment clinics at law schools around the country. I think I read somewhere that there, at least in the past couple of years, there were at least 32 such clinics, and those are great, and they provide an important role and also give experience to developing lawyers who want to become interested in and work in the area of First Amendment litigation, and also to provide help to individuals who couldn't do it on their own. And then finally, you do have these independent public-minded journalist organizations like ProPublica, the Markup, and the Intercept, which have really, particularly, we've all seen some major stories coming out of these news outlets in the past, months and years that are, extremely important. So to the extent that we all want to continue to advocate for increased funding and sustained funding of those groups, that's important. In terms of the work we've been doing, and Frank, you mentioned, actually we really focus on the digital age, and you're right that we have, as much as we're happy that we have an independent funding source and that we have stability at Columbia, we're still somewhat limited, group. And, I think we have maybe a dozen full-time lawyers, which is great. We've grown a lot, but as a result, we want to maximize our impact. So we try to focus on cases where, we can't file freedom of information claims for any issue that seems interesting. And so we try to get ones that are either related to a new issue that has to do with, digital surveillance or national security with a technological aspect, like asking the government for information related to its consideration of the use of spyware, but also to do cases where we can hopefully have an impact beyond just the specific documents sought in the case. And then we also have, as Frank mentioned at the beginning, one of our sort of marquee cases since the Institute has started is we brought a lawsuit in 2017 against President Trump for blocking people from Twitter. And at the time, there was very little case law on whether or not if the government or a government agency or official operates a social media account, is that a First Amendment and blocks someone, is that a First Amendment violation? Luckily, we had this great article by Lyrissa, which we're still using, excuse me, I have a frog in my throat. But Lyrissa really, built or outlined the argument of that when the government operates a social media account, which, 10 or 15 years ago, very few were doing, or it wasn't even around. But now most, elected officials and most government agencies have a social media account, either Twitter or Facebook or Instagram. And when the government is operating such an account, it is essentially functioning as a public forum. And there's a lot of law from the, mid and late 20th century about that if there's a public forum where the government has opened up a space for members of the public to engage in speech, the government can't discriminate in that forum and exclude certain voices based on viewpoint or potentially based on content, depending on what kind of forum it is. So we were, very fortunate. Well, it wasn't fortunate because in talking about these new kinds of plaintiffs, we had individuals who were that were the plaintiffs in the case against Trump. They were kind of just individuals across the country who had spoken up and were very activated by, in their activism against Donald Trump. And they wanted to reply to him when he was tweeting from his account that he was using while he was president, and he blocked them. And these weren't necessarily high profile individuals, but they were, a sociologist, a police officer, and a songwriter, and an activist, a comedian who just had said something not even particularly incendiary in replying to Trump, and they were blocked. And, they reported at the time that, they were definitely partisan. They opposed President Trump's presidency, but they really wanted to get their voice out there. And they said it seemed kind of shocking to have the president of the United States block them from participating in this speech forum, that it really did seem just like real classic censorship. So, that case has been really both, rewarding, and we've been able to develop the law in this area more so that it's not just applying to President Trump, but applies to public officials and government agencies at all levels of government and across the country. So, that's what we are proud of our work. But as I mentioned, necessarily we are also limited in our resources, and we can't take all of the cases. And, we care very much about government access. And like I said, we want to focus on issues that would, apply beyond just the case, but in terms of specific access to specific proceedings, those are the kinds of things that I think that the news industry could have done previously. And, we also, just on a little small example, but on these cases about being blocked from social media accounts run by the government, we get requests, probably every week of someone who was blocked by the mayor of this town or the school board chair of that town. And we just can't take on all of those claims. So the need still is there. And I very much, agree with Ronell and Lyrissa about one potential, seems like fix in this area is legislative fixes, but of course you need the appetite, the legislative appetite for that. So that's kind of a maybe uphill battle. We'll see.
Well, I've got all kind of questions, but I see some good ones dropped in the Q&A, so let's make sure those get answered first. Whoever wants to start taking this one, there's a question about the recent arrest of the Massachusetts Air National Guardsman who was accused of doing essentially a junior WikiLeaks document dump, where he got a hold of documents by virtue of his National Guard position, publishes these documents on the web. And the question is, now that people are able to go on social media or chat sites and unload these potentially sensitive national security documents, is that a headwind for the press in any way? Does that complicate the argument for freedom of the press when this sensitive information is floating around out there and potentially the press could just repeat it and republish it without taking much legal liability?
So I think that story is a little disturbing for a number of reasons. One is it appears that the press was instrumental in unmasking the leaker, and I'm wondering what they thought their incentive was in doing that. I presume they think it's newsworthy, but had that been their confidential source they were reporting on, the Pentagon Papers, presumably they would have gone to jail to protect the confidential source. So why are you helping the government to uncover this leaker? And I think that really highlights one of the assumptions of kind of the golden era press cases. Assume that there's going to be an adversarial relationship between the press and the government, and the press won't be an investigative arm of the government voluntarily. So that's one aspect of that gives me a little concern of what the press think their role is there. And I know there have been some tweets by a New York Times reporter that was later taken down where he made that argument, and then he later took that tweet down because I think they see it might undermine their credibility if it looks like they're too cozy with the government. But the other thing is, this control of information is always, there's a realpolitik here about you can't keep a complete lid on information, and it is a power struggle between the government and the forces that would like to uncover government secrets. I think technology often cuts in favor of the government, but of course in a document dump like this, where you have the original documents just being easily plopped into a social media app, there are some cross-cutting forces that undermine government secrecy in a way that does potentially affect national security. So I don't know how that cuts in terms of our I hope it doesn't cut in favor of enhanced criminalization for people receiving government documents, because that really could redound to the detriment of the press. But I think the press should be aware of the fact that they are the beneficiaries of leaks so often that perhaps they shouldn't cooperate in uncovering leakers.
Yeah, I would just add to that. I don't think that every news organization by a long shot has access to this particular document dump. You had to be in the right place at the right time to get it. But the Washington Post does appear to have access to it. And I've been following their coverage, and they've actually been quite selective in adding their own reporting to particular documents rather than replicating the document dump, which was the same with WikiLeaks as well, right? You didn't see the Washington Post and the New York Times just replicating the document dump. You saw them adding their own original reporting selectively to the things that they thought were important, and actually exercising judicious judgment in not republishing each and every bit of information. So
that's what we want from the press. I think that's the press function that we're worried we're losing.
Yeah, one of the, I mean, just sort of to take that up to sort of 33,000 feet and talk about what I think are the major issues on deck for us in the coming couple of years. And this is a completely self-serving thing that I'm about to say, because it's a thing that I'm going to be exploring in the next couple of years. It's actually also serving Katie, because Katie's organization is hosting me while I explore this in the next couple of years. But I'm super grateful. My co-author Sonia West and I are really grateful to have the chance in the coming year. We're going to be senior visiting research fellows at the Knight Institute, and the major question that we're going to have on deck is sort of identifying and preserving the press function. Sort of what is the constitutionally valuable press function? What does it look like in this new political and media landscape? And how do we craft law and policy and constitutionalism that recognizes it and protects it? And I think the truth is that part of what we've seen from our backward look here is that it's questions that these are questions that we didn't really have to ask all that carefully in the old era, because there was this, firstly, because there was this very readily identifiable press, right? It was Walter Cronkite, and it was the Richmond newspapers, and it was Press Enterprise. Like, they were the press. It was the daily, the 2 daily newspapers in every major community, and it was the 3 TV stations that brought you the news at night. And whatever they were doing was probably the press function, and they were probably the press. But it also was the case that the press were so incredibly well resourced that they could throw open all of they could litigate everything under broad constitutional protections that redounded to their own benefit, but also to everybody else's. And there wasn't any need to sort of parse out who's really engaged in the kind of proxy for the public kind of work that might be worthy of special constitutional protection, that might warrant carve-outs from other systems of regulation, or that might require special access in various places, right? The court just sort of punted on a lot of those issues, and the press punted on a lot of those issues. And I think now in our changing media environment, we have hard questions about what constitutes the press function, and what the press clause of the Constitution might be doing that is separate and apart from the speech clause. And that's a piece of what's going to have to get litigated. And my big question is, who's going to litigate? I mean, Katie is, yay, but sort of who else, right, is going to litigate that? It's a complicated time to be thinking about parsing out that kind of protection. But I think those press functions, they're not special for the press. They're special for all of us. Everything that we've heard here has been about how there are functions being performed that are valuable not just to the performers of those functions, but to all of us on whose behalf they're being performed. And thinking about how to make sure that those benefits continue has to be top of mind to us. I'm convinced that it is a democracy preservation issue, that we have to do it in order to maintain the health of the republic.
We've got a lot of good questions. I'm going to try to go rapid fire through these. I want maybe Professor Lidsky to take the first crack at this, because you mentioned that there is a sort of a growing conversation going on nationally about, is there a role for direct government subsidization of news media, which used to be unthinkable, and news organizations still largely recoil at this. One of the questioners mentions that under Mayor de Blasio, the New York City started a policy saying that you have to direct city advertising to local community media, including ethnic community serving media. And the questioner says, this seems great, but does this increase the risk of dependency on government as a source of subsidization, with the possible attendant risks to the independence and the autonomy of the press?
At the beginning of my career, I would have been opposed to such a thing. But at the point we are now, I have become a supporter, and I think there is more interest in this. And I think our experience in seeing state supported or state assisted media in other countries makes us maybe a little more comforted about too much interdependence between government and the media. But what I see is with and I can't say decimation of newspapers because that would mean 1 in 10. So that doesn't even describe the situation. But with the evisceration of talent from newsrooms, we need something to build up the expertise to do what the Washington Post did in the story we just talked about, and to expertly summarize what's relevant, what's not, what might be too much of a threat to national security, and maybe the public doesn't need to know, and make those judgments that come from a lifetime of expertise in following a particular topic. So I think we might need government assistance to build that expertise.
I would just add in that I think, government funding or public funding, and that's become a big, controversy right now in terms of Twitter labeling certain, NPR and others as being state funded or government funded. But I think, if you recognize that journalism is a public good, then public funding makes sense, but that you also obviously need to have safeguards to ensure that it doesn't just become government propaganda, and including safeguards when you have a change of administration. I know during the Trump administration, there was a lot of controversy over Voice of America and, what was taking over there. So anyway, I think institutional safeguards are good.
Well, and I will say, I was on a panel last month about where this question came up at UCLA Law School, and my rejoinder to the government funding question was the best thing and the first thing that the government could do is get the hell out of the way between us and our information, because as you mentioned, Professor Lidsky, they're inflicting unnecessary costs by way of these 5 and 6 and sometimes 7-figure FOIA bills that are entirely unnecessary. They should be affirmatively publishing all those documents and data free of charge on their website now. And so before we start asking them to write us new checks, we ought to ask them to stop imposing unnecessary costs on the information that we already have that belongs to the public and that ought to be free of charge. That's my soapbox moment. This one is, I think, let's start it with Katie, but Lyrissa, since you mentioned Twitter files, you might want to chime in on it as well. We have a question. Have any public interest lawsuits been filed about FBI, DOJ, trying to influence social media companies and how they decide what to platform or not platform, or shadow banning people or misrepresenting which posts are trending? What's the sort of legal lay of the land there?
Well, Lyrissa may know more about this than I do, or probably does, since I know not as much, which is that I definitely think there is a concern about, and for some reason, the word jawboning is just all of a sudden in my sphere of hearing in the past several months, but the idea of jawboning, of when the government seeks to use pressure to pressure a social media company to carry or not carry a particular viewpoint, I think that would present, extremely troubling First Amendment concerns. If the government, basically depends what kind of pressure it uses, not just spending money, but, viewpoint-based discrimination would be a problem. But I'm not aware of lawsuits where, there are private lawsuits against some of the privately owned social media companies arguing that they have taken down people based on viewpoint. And if it's just involving just a private, company with a private individual saying, then it doesn't raise First Amendment issue because it's not state action. But I think one of Trump's lawsuits actually was based on this idea of a sort of a jawboning theory, but Lyrissa, you probably know better than I do.
So the Missouri Attorney General Ehrich Schmidt has some litigation going. The problem with that, and with some of the legislation in Texas and Florida against social media companies responding to such pressures in their editorial process, is that some of it is, being used for partisan purposes as a signaling in partisan ways. And so I just worry that the public interest won't be fully, I mean, I'd like to see some transparency. I'd like to see the social media companies have some transparency obligations about when they respond to government requests and how many such requests they get. Because the remarkable thing to me in the Twitter files was just they practically had an embedded government unit telling them to take stuff down and take whole, you know, like large numbers of takedown or shadow banning requests. And I think transparency would cure a tremendous amount of that. But I'm a little suspicious of the way we're going about trying to correct it.
So on that point, right, the Supreme Court is going to tell us very soon whether they will take a pair of cases that are pending there right now, one out of the Fifth Circuit, one out of the 11th Circuit, called the net choice cases that are exactly addressing what you just described, the extent to which a state government can actually tell a social media platform what they must carry and not carry, or who they must platform and can deplatform. So there's that out there. I dropped into the chat a link to Professor Ehrich Goldman's blog. Anybody who's interested in the First Amendment and social media, that's a must follow. But he's written extensively about there have been some of these jawboning cases from time to time being brought, and there's a distinction between just expressing, right, because the government also gets to express an opinion, and there's a difference between expressing an opinion versus using compulsion. And so far, plaintiffs have had a hard time surmounting that goal, because the government can always speak as sort of a marketplace participant. What they can't do is use their authority to compel people to speak in ways that they don't otherwise want to. And so far, the first round of these kind of deplatforming plaintiffs have had no luck in establishing that it went beyond just, as we say, jawboning, just expressing the government's view versus actually crossing the line into enlisting that platform as a kind of a collaborator with the government, which might give rise to a First Amendment. So the really interesting question. Is archived news disappearing, and are tools like the Wayback Machine filling that void? All of you who write law review articles have probably experienced this link rot, right, where the articles that you were depending on suddenly disappear, or that you linked to suddenly disappeared. What is the landscape there? Is there any effort kind of to preserve news from disappearing?
Well, this might well be another manifestation of the resource problem that we just described before. The entities that we might have expected to have produced and then to have maintained archives of important newsworthy matters of public concern are the very entities that they're not just losing their news gathering budget and their legal budget, right? They're also losing their budget for storing and maintaining information that they might provide to us. So I think it's a cluster of issues of sort of us figuring out all of the things that local journalism used to do for us and identifying belatedly the things that they no longer can do for us, and how we need, if we think of it as a public good, right? If we think of it, if we think of this as history, right, or important research capacity, or even if we think of it as important for purposes of ongoing accountability, to make sure that people who said things in the past, right, are not saying things that are contradictory to things that they are saying now. Those are things that we have to resource in some way. One of the things that I think is really interesting, the interesting underlying premise of this question, of course, we're probably better archived today than we were in 1960 because the internet exists, and because we have databases that have more storage capacity and the ability. So our ability to hold on to our news gathering as a record of what's happened and as an accountability measure is greater. It's just that the cohesive incentives to do so might be shifting. I've experienced the same thing that the questioner asked, a deep frustration when looking for, even wanting to make a point of the sort that I just described, wanting to say, politician X is saying this thing, and I recall that something different was said at some earlier stage, sort of looking around to try to find the previous statement can be really complicated.
So I love this question about this references the commenter's experience in Ohio. Certain newspapers from big cities are joining together to actually share resources and cover issues. I would say, by the way, this is also going on in New Jersey. There's a hub of this at Montclair State at New Jersey that's very interesting. Do we need to set up nonprofits to try to cover the holes in coverage like this? There need to be some sort of organized effort to fill the gap. And the NPR PBS public broadcasting model is being raised here, which, by the way, is being experimented with somewhat in Illinois, in the Chicago area. Anybody have any thoughts about sort of what that model might look like, or whether that's a direction in which we see the field evolving?
I think there are lots of creative solutions that are being explored by people in the journalism space and also by people in the nonprofit space. And among them are these sort of collaborative endeavors. In fact, there are now really interesting talks happening about other ways to sort of collaborate and make news gathering and news delivery on a local level more efficient. AI may well prove to be one of these tools. You can imagine a story that is a national story about something that's happening and some holes that are spaced in it for local statistics, right? So that you say the national story happens and then we need a local story that says, and the details about how many people are on Medicare in Utah or how much funding goes to Medicare in Utah would be left there at the end. And that's the sort of thing that could be generated and passed along through local news outlets to give more local news angle to people of bigger national stories. It comes with its own set of really complicated, hairy issues about when news is being generated by people who are not not by people, by entities that are not human, and the kinds of dynamics that might come into play there. But I do think taking advantage of law and technology and cooperation and philanthropy and public funding, right? All options need to be on deck, both for thinking about filling the news gathering gap and for filling the legal transparency gaps that exist as newspapers disappear.
But I also say this is sort of on the legal side. I know that the Reporters Committee for Freedom of the Press has begun a program of having lawyers in regions with an express purpose. We're working for a nonprofit to assist journalists, local journalists, or consortiums of local journalists with various access issues. So I mean, I think that's another model in terms of not just focusing on the journalists, but the legal support.
So there's a question. I think Professor Lidsky, you probably started off answering this in the Q&A, but do you want to answer it for everybody about in what ways does social media, I guess, not foster a climate for the fact-based discussion of issues of public concern? And is there anything that can be done? And we talked about state efforts to regulate content of social media and how those might themselves run up against the First Amendment. Is there anything that can be done to kind of help social media to evolve in a direction where it actually replaces what we've lost in the community news environment?
This is one where I'm a little less sanguine about government involvement, because I really think the government's involvement in shaping social media forums may be pernicious. But I mean, the internet and then social media eviscerated the funding model that supported traditional news. At the same time, there's some evidence that social media is making us more hyperpartisan because we only seek out information that confirms our pre-existing ideological biases. We only talk to people that have our pre-existing ideological biases, or if we encounter other people, we engage in hyperbole to get our message out, because otherwise you get lost in social media. So we all talk in exclamation points all the time, which is not especially conducive to wise public discourse. But I know Ronell and Katie probably have ideas about this one too.
Yeah, I mean, a major concern that I've expressed elsewhere in my scholarship is that the social media model as we currently have it, if we're trying to think about the way that it maps onto the press function in particular, right, the sort of core democracy enhancing press functions of news gathering and enhancement of governmental transparency. It's a weird fit because social media is really designed for repeatage and not for reportage. So there are some social media tools, I would say up until fairly recently, Twitter, are sort of designed to be really great disseminators of news, but secondarily. And the question is sort of who's the boots on the ground, who is there at the county council meeting, and who, if locked out of the county council meeting against state open meetings law, litigates that lockout to make sure that there's something to tweet and then something to pass along, and who's sort of providing the context, right? Instead of saying just that this happened, say, you know, this is the 10th such time that this happened in this region in the last year, or this is the arc of what this looks like. I think of those things as the core operations or some core operations of the press function. And as of the moment, social media by itself as a model isn't really designed just to serve those kinds of functions. It does a remarkable job of connecting us to each other to have the subsequent conversation. But, Twitter and Facebook and Google, even other tech platforms, Google doesn't have, a reporter on the ground in Ukraine. And so us thinking about the ways that the technology helps us be better able to talk to each other doesn't solve the beginning problem of how we perform the core press functions and the legal protection of the press functions that we have to have in order to be generating the kind of conversation that we want to have in those spaces.
Well, thank you for introducing Google into the conversation, because I want to give Katie Fallow one moment to address something before we wrap, and that is, Katie, one of the realities we've talked about that old school publishers can't pay the freight for these press associations or maybe make huge charitable contributions to nonprofits anymore, but who does have money is the tech sector. 48% of all the digital advertising in America today goes to two companies, Google and Facebook. Are those companies carrying their weight as funders of First Amendment legal challenges? And also, are they stepping up as plaintiffs, both on their own behalf and on behalf of the speakers who use their platforms? And could more be done there?
Yeah, I think that those companies, the social media companies in particular, but, Google also, have not seen themselves, even if they're getting all this advertising related to content and related to news content, which sometimes is just built off, or often has been built off the back of traditional news outlets, have not seen themselves as publishers or providers of news. They've just seen themselves as, in part, if you look at, the Section 230 immunity for social media companies at any internet site that carries third-party content, they say, well, we're sort of not publishers in that way. And I think certainly at the very beginning, in the sort of the early part of the 21st century, I do think to some extent, some of the social media companies, on one hand, as the Twitter files show, have been giving an enormous amount of information to the government in certain circumstances. On the other hand, some of them have taken stands at various times to protect the anonymity of some of their users against, government subpoenas. And then more recently, I think, we've already alluded to these cases coming out of Texas and Florida, where those states have sought to essentially impose must-carry obligations on the social media companies, saying you cannot apply your content moderation rules in a way that would be considered viewpoint biased. There's differences between the two laws, but in those cases, on one hand, you can see them, and they're doing it through this association, essentially, of the tech companies called NetChoice. It's not the individual companies filing these lawsuits, and they're challenging under the First Amendment, and they're drawing on cases that were, brought by newspapers, including Miami Herald, about protecting editorial independence from government, essentially must carry content obligations. So on one hand, you can see their role in these cases. Clearly, it's for their bottom line. I don't want to be, naive, but that to the extent that they are continuing to assert these issues of editorial independence from government control, that could, benefit people beyond just the companies at issue in these cases. But I still don't think they see themselves, they're not seeking, they're not filing emergency motions for access to important trials. Or maybe they are, but I'm not aware of that. So I don't want to say for sure, but.
Well, I could listen to this group all day, but our time has blown through past this. And so I want to thank Professors Lidsky and Anderson-Jones and Katie Fallow from the Knight Columbia Institute for joining us and sharing their wisdom and their perspective. And thank you for watching this free ABA webinar. We thank you for taking time out of your schedule to share your excellent questions and your good thoughts. The ABA section of Civil Rights and Social Justice provides free webinars and resources for legal professionals and advocates nationwide. We hope that this helps you and as a resource in your work. And again, if you can, please consider joining and becoming active in the ABA. You can do that at americanbar.org/CRSJ. Best of luck in your work. Stay safe, everybody, and have a great